I'm Aaron Parks. I get asked the question, in what situations should a person definitely not do their own probate? Or I guess you could phrase it differently. When is a probate situation likely to become so complicated that a person really needs an attorney to handle the probate for them? Most judges in Oklahoma are very understanding of you doing your own probate as a way to help save money. They tend to be helpful, and in areas within their discretion, it may even give you some extra leeway. That doesn't mean you can cut corners. Just because a judge signs off on a probate order does not mean that an insurance company or title company is going to be fine with it. If you don't follow the Oklahoma statutes, you're not doing yourself any favors in the long run. Following the probate statutes exactly is critically important. The bad news is there are a lot of statutes that apply to probate. The good news is that it's not that hard to comply with the basic probate process. However, there are a few circumstances where you should not try to do your own probate. One of these is when you know there is an issue in the probate case that is likely to create problems. For instance, if Dad cut his daughter out of the will while he was on his deathbed in the hospital, you can have a pretty good idea that's not going to go over well. These types of disputes are usually known well in advance of filing probate, and probably everyone involved has been getting ready for a fight for a while. These situations happen most frequently in cases where there are heirs from previous marriages, but not always. If you have a reason to believe that someone in the family is unhappy with things related to the property and the estate, you'll be best served hiring an attorney to handle the probate for you. Another area that you'll want help with is if the estate is very large or has complicated business or partnership interests. These situations involve much greater management of assets within the probate proceeding, which means additional court filings, hearings, and questions of who has what authority. A third area that you will want to avoid doing your own probate is if the estate is subject to the estate tax. The record keeping, management of assets, and tax reporting requirements are far more complicated, and you will want the help of an experienced attorney and a CPA. The current federal estate tax exemption is over $11 million, so if this is a problem for your estate, spend the money to get professional help. It will be worth every penny. The last issue involves the sale of real estate inside the estate. In many cases, you'll have a choice whether to sell real estate inside the probate or outside the probate after it's completed. Selling real estate inside the probate isn't terribly complicated, but it does require strict compliance with the probate statutes, or the closing company will stop the sale and make you go back and fix the probate issues. You won't have good title, and the closing company will not issue a title insurance policy unless the probate statutes were followed exactly. So you may not know you have a problem until you get ready to close. If you're selling real estate inside the probate, you can do it yourself, but you have to proceed carefully. In most cases, probate can be done without needing an attorney to handle the whole thing for you, if you're willing to do some of the legwork yourself and you're careful to follow the statutes. Because it's primarily procedural in nature, checking the right boxes in the right order should allow you to get through it just fine.